Hello, this is Captain Chaudhari. In my last video, I had talked on the difference between the Hague Visby Rule and the Hamburg Rules. There we had talked about the documents, bills of lading, etc., contract of carriage in the two conventions. In this video, I'm going to talk about the liability. What is this liability and what is this burden of proof which is talked about in the two conventions? Let us understand. Now both the conventions, Hague Visby Rules as well as Hamburg Rules, the liability is fault based. Now the fault has to be established. This is very clear that fault has to be established for the liability. Now once the fault is established, now what is the difference between the two? The difference is allocation of responsibility of burden of proof. So we will see what is the difference in Hague Visby Rules and Hamburg Rules as far as the responsibility of burden of proof or onus of proof is concerned. In the civil cases, it is the plaintiff who has the initial responsibility about burden of proof. He has to establish the facts, he has to demonstrate the validity of claims by preponderance of evidence. The preponderance of evidence means the plaintiff is able to convince the judge or jury that whatever is being stated, the probability of the statement or the event is more than 50%. In the criminal cases, it is the responsibility of prosecution to prove the guilt of the defendant. Now let us try and understand what is the shifting of burden of proof. We were talking about a civil case, and let's say plaintiff provides such information or such facts that the case becomes prima facie clear. Now the defendant has got two options. One, he would counter the evidence that is provided by the plaintiff, or he should have some alternate explanation. Now when a trial goes on, there is a continual shift of burden of proof on one side to the other side, and that would happen as the case progresses and as each party provides their statements or their facts. That's the facts from their side. Under Hague Visby Rules, let us look at following two situations where the carrier is exonerated from the liability. Number one, the damage that is caused because of unseaworthiness, unless it was caused because of the breach of the obligation of carrier to observe due diligence and care for the cargo. And other situation is when the damage has occurred because of the fault of master mariner, pilot, or the servant of the carrier in navigation and the management of the ship. In case the cause is unseaworthiness, as we know in Hague Visby Rule, before and at the beginning, it is the responsibility of carrier to provide seaworthy vessel. So if the cause is unseaworthiness, it is up to the cargo owner or the claimant. The burden of proof lies there that the ship was unseaworthy. Or if the carrier did not care for the cargo, he did not observe due diligence, once again, it is the responsibility of cargo owner to prove that. Article 3 of Hague Visby Rules, responsibilities and liabilities. It says the carrier is bound before and at the beginning to exercise due diligence to make the ship seaworthy, to properly man, equip and supply the vessel, to make the holds, refrigerating, cool chambers and all the parts of the ship where the cargo is to be, goods are to be carried, fit and safe for carriage, reception and preservation of the cargo. That is what is the responsibility given to the carrier by Article 3 of Hague Visby Rule. There is no such reference in Hamburg Rule, but this is because of the protection that is provided by Article 5 paragraph 1. It says that in case of any damage, the carrier is responsible. Unless the carrier can prove that carrier or his agents, carrier's agents, they did everything possible, they took all the measures to prevent or avoid the occurrence or the consequences. So thus the Article 5.1 provides the basis of liability. The carrier is liable for loss resulting from loss of or damage to the goods, as well as from delay in delivery if the occurrence which caused the loss, damage or delay took place while the goods were in his charge as defined in Article 4. Unless the carrier proves that he, his servants or agents took all measures that could reasonably be required to avoid the occurrence and consequences. Specifically, the carrier under Hamburg Rules must prove that he took all reasonable measures to prevent the loss or damage. This is called reversal of burden of proof. Unlike Hague Visby Rule, where initial burden of proof was with the claimant, that is the cargo owner. This means that the claimant in Hamburg Rules, he doesn't have to prove anything. He has to just demonstrate that the damage occurred while the cargo was in the custody of the carrier or the care of the carrier or in the charge of the carrier. Article 3.2 of Hague Visby Rules states, subject to the provisions of Article 4, the carrier shall properly and carefully load, handle, stow, carry, keep care for and discharge the goods carried. So these responsibilities which are stated above are the absolute one. They are not the ones which will end up when the voyage starts. In fact, they will be continued for the entire voyage, where the regulation says that it is the responsibility of the carrier to load, handle, stow, keep, carry, care for and discharge the goods. In Hague Visby Rules, the cargo owner has to prove two things. Number one, the damage occurred while the cargo was on board. This means that he has to provide a clear evidence, and for that what he needs is clean bills of lading stating that the cargo was loaded in sound condition, the packaging, cargo, etc. was sound, and then he has to compare that with the condition of cargo at the time of discharge. So this becomes a prima facie evidence of the damage that happens during the voyage. And second thing is the responsibility of the cargo owner is to prove that the damage was caused because of unseaworthiness. Subsequently, the carrier must prove that the cause of damage that has happened, it falls within one of the exceptions which is provided in Article 4, paragraph 2. Now, once again, it is the turn of the claimant, that is the cargo owner, and he has to prove that the damage was actually caused because of unseaworthiness. Now, where the claimant is able to prove that the damage was because of unseaworthiness, it is the turn of carrier to prove that the ship was seaworthy before and at the beginning of the voyage. And during the voyage, he exercised due diligence. This means that suppose the court says that the damage was caused because of unseaworthiness. It is the responsibility of carrier to show that the ship was seaworthy before and at the beginning, and during the voyage the damage that has happened has, even if it has happened because of the unseaworthiness, he has exercised due diligence in ensuring that the ship is seaworthy. So sometimes there is an exemption between total exemption of liability and limited liability. So here it is worth understanding a ruling that was given by Supreme Court of one of the countries. It said in this particular case, it was said that before the carrier can make use of the exemptions which are given in 4.2, it is very important that the carrier proves that reasonable care was taken to prevent the harm to the goods. Now let us look at the liability situation when it comes to the live animals. Hamburg Rules, where the live animals are included in goods. With respect to live animals, the carrier is not liable for loss, damage or delay in delivery resulting from any special risk inherent in that kind of carriage. Article 5, paragraph 5 of Hamburg Rules states, if the carrier proves that he has complied with any special instructions given to him by the shipper respecting the animals, and that in the circumstances of the case, the loss, damage or delay in delivery could be attributed to such risk, it is presumed that the loss, damage or delay in delivery was so caused, unless there is a proof that all or a part of loss, damage or delay in delivery resulted from the fault or neglect on the part of the carrier, his servant or agent. So if the carrier proves that there are certain particular types of problems or risks involved with carriage of certain animal, and the damage has happened because of those reasons, or if the claimant is not able to prove that the damage is caused because of the fault of the carrier is exempted from liability. Carrier will not be liable. So unlike the other situations where the burden of proof was with the carrier to show that he has taken all the care, here the things are reversed. Here the burden of proof that the fault was of carriers lies on the claimant, that is the cargo owner. Article 5 paragraph 4a says the carrier is liable, number 1, for the loss of or damage to the goods or delay in delivery caused by fire, if the claimant proves that the fire arose from the fault or neglect on the part of the carrier, his servant or agents. 2. For such loss, damage or delay in delivery which is proved by the claimant to have resulted from the fault or neglect of the carrier, his servant or agents, in taking all measures that could reasonably be required to put out the fire and avoid or mitigate its consequences. This means that, once again, like live animals, it is not the responsibility of the carrier initially to prove that he is not guilty. It's not his fault. Whereas it is the responsibility of the claimant, that is the cargo owner, to prove that fire arose because of the fault of carrier. Now here the problem for cargo owner is twofold. Number 1, he suffered the loss, and second, he has to prove that the loss was because of the fault or negligence of the carrier or his agents. Now Article 5 paragraph 4b says, in case of fire on board the ship affecting the goods, if the claimant or the carrier so desires, a survey in accordance with the shipping practices must be held into the cause and circumstances of the fire, and a copy of the surveyor's report shall be made available on demand to the carrier and the claimant. Now, when it comes to comparing the Hague Visby Rules with Hamburg Rules in respect of liability, there is a special reference to this proportionate liability in Hamburg Rule, which is not there in Hague Visby Rule. We are not talking about dividing the liability between the carrier and the agent. I am talking about the liability of the carrier or agent versus the liability of some other causes for which the carrier might be exempted his liability with his liability. So there is a concept of proportionate liability, and that is as follows. Where the fault or neglect on the part of carrier, his servant or agent combines with another cause to produce loss, damage or delay in delivery, the carrier is liable only to the extent that the loss, damage or delay in delivery is attributable to such fault or neglect, provided that the carrier proves the amount of loss, damage or delay in delivery not attributable thereto.